Well, good morning or good afternoon or good evening, whichever it is for you. We're continuing our march through the text for criminal law here at Wake Tech. We're in Chapter 6 now, which is going to be covering when force is an acceptable alternative in a civil society. And one of the things about this chapter is there'll be a little bit of specific North Carolina law involved. So for those of you that are taking the course here in North Carolina, this will be particularly apropos. Also, this is a relatively short chapter. So there's only about 25 slides, so I think we'll be finished a little bit faster than the typical hour I try to run these at. But in any way, having said that, let's go ahead and move to talking about the biggest application of force for most of us, and that's going to be self-defense. Now, there's a lot of contention about this, and I think, like a lot of things, you can blame popular culture for a lot of misapprehensions and misunderstandings of what's going on. It's actually a little bit more complex than you shove me, I shove you back. Let's put it that way. So when we're talking about self-defense, we're talking about when can I essentially lay hands on someone. Now, I'm going to stay clear of any sort of verbal assault or anything like that. I'm going to talk about a physical assault or battery. And remember, a quick distinction: under the common law, the term assault meant that you place someone in fear of a battery or an offensive touching. So the battery was the offensive touching. If I punch you in the nose, right, that is a battery. As I cock back my hand and you see it, that is the assault. Now, it doesn't have to be an act of violence like that. It could be something that doesn't necessarily physically harms you, but nonetheless is offensive. So let's suppose I go up to a person and I kiss them against their wishes, or I fondle them. I grab their genitalia or their breasts without their permission. Now, I'm not hurting them in the physical sense that those parts of their bodies suffer a cut or an abrasion, but it's a violation of that person's individual space, so it's offensive. And you can see, like, as I come up to do something like that, right, if I come up and I act like I'm going to touch you, or I act like I'm going to kiss you, you can see how that could be an assault, right, because the assault is the threat of it and the battery is the completion of it. So you can use some level of force to prevent someone from committing the battery. So if I'm coming up to punch you in the nose, you can grab my arm. If I'm coming up to kiss you, you can push me away. If I'm trying to beat you with a club, you can hit me to stop me. So the legally sufficient reasons, the things that are going to allow you to use force against another person in self-defense, is going to say, well, first of all, the other person has to be threatening unlawful force. If a police officer is coming up to you and saying, okay, I just saw you rob the bank. You said, yeah, I robbed the bank. He goes, all right, I'm going to put handcuffs on you. And you say, well, you can't. I'm not going to allow you to. You don't have the right to stop the force that that police officer is now going to exercise. So we say the other person is using or threatening to use unlawful force. If the force is lawful, then you do not have the defense of self-defense or defense of others. You are also supposed to use the level of force which is necessary. And the terminology I prefer there is proportional. If someone is coming up to slap you, you can knock their hand away, but you can't shoot them in the belly. If someone is coming up to give you an unwanted kiss, you can't stab them in the chest. So it should be proportional to the threat that is being faced. It has to be, and this is the last requirement, reasonable. So first of all, it has to be necessary to do it. It has to be reasonable to do it. It has to be what I say is proportional, kind of combining those two things. And they can't have any sort of right to lay hands upon you or act in violence themselves. Whether or not the force is justified depends on lots of factors. Now, what kind of force are we talking about here? Who is using it? Is it a police officer? Is it just someone on the streets? What are the circumstances, the individual circumstances leading up to it? So let's look at a modern model penal code section here. This is section point zero. And we're going to get to North Carolina specific one in a minute, as I said, but this is kind of a general definition. Section 3.04 of the Model Penal Code, which is just kind of an attempt to create a universal legal code, criminal code, provides that force can be used in self-protection when, quote, when the actor believes that such force is immediately necessary for the purposes of protecting himself against the unlawful force by such other persons on the present occasion. And it's got a lot of stuff packed in there in legalese, but you can see it's got the level of force, okay, that it says, you know, unlawful force, immediately necessary, that's the level of force you're going to use, what you believe, the individual circumstances, all that's packed in there. Now let's talk about North Carolina, something I'm a tad more familiar with. If we're looking at a police officer, right, in the use of force, I have a kind of chart over there to the right, left of your screen. But let's look at what the statute is. The statute says North Carolina General Statutes, 15-51.3, use of force in defense of person. And it says a person is justified in using force, except deadly force, which is force that's likely to kill or cause great bodily harm, against another, and to the extent that person believes reasonable that the conduct is necessary to defend himself or another against the other's imminent use of deadly force. If justified, you are immune from civil or criminal liability. So when can I shoot? When can I stab? You know, I think it's easy to see if someone's coming to hit me, I can hit them back. But when can I, in order to stop someone, kill them? So we often say that it is a continuum of force. So if we look at police officers, very often, and it got cut off there, that slide, but it says the presence of the officer alone is sufficient. You know, most of the time the police officer's there, and that's going to prevent force. But sometimes he has to communicate. He has to engage in, he has to tell people, don't do that. So that kind of ramps up the continuum of force. And then sometimes he has to take physical control of situations. Sometimes a police officer has to use his hands. And of course, beyond hands sometimes, and that's the next level, level 4, he's got to use defensive weapons or intermediate weapons, tasers, batons, to extend force. And then of course sometimes he has to disengage. If it's a situation where, yeah, I mean, he could control it by using lethal force, but he's attempted to use defensive weapons, it hasn't worked. The threat is still present, but it's not a threat to him, okay, then the police officer shouldn't escalate to the last level, level 6, which is lethal force. Lethal force, essentially, the officer himself has been placed in the situation where, okay, I've tried to control it by being there, I've tried to tell them what to do, I've tried to handle them physically, I've tried to handle them with non-deadly weapons. I don't have a reasonable opportunity to retreat, or it would be unsafe for myself or others to retreat. And at this point, he's got the right to use deadly force, which is going to mean shoot. Okay, so self-defense and defense of others, because there's two situations here. Now, I'm a married man. Obviously, I can defend myself, my own body, but I could also defend my wife in a situation, or my children, or someone that was under my custody or control. Self-defense, the elements to evaluate whether an act of force of self-defense is justified include, what have you done? So, you know, think about this. If you're in a bar and you get drunk and you throw a drink on someone's face, or spit in their face, or slap them, and then they hit you back, you can't say, oh my God, he hit me, he committed an assault. Now I can use force against him. No, you're the aggressor. So was there any unlawful action that you committed that underlaid the escalation of force here? The necessity to defend oneself immediately. Now, this is somewhat contentious because we've got the stand your own ground laws, but basically, is this an immediate situation, or are you essentially going and looking for a fight? And then how reasonable is what you did? And this is going to go again to things like proportionality. Now let's go back to that same bar, and let's suppose I'm drinking there with a friend. We'll call him John Doe. And the defense of another says the elements to evaluate whether an act of force is for defense of another unjustified include the unlawfulness of the action towards the other, the necessity to defend immediately, and the reasonableness of the act. So let's consider this. I get up to go to the bathroom. My friend John Doe is sitting there drinking, and while I'm gone, he commits an assault on another. He comes up and smashes a beer bottle on someone's head. That guy, we'll call him Black Bart, stands up and throws a punch. Now, at this point, I come out of the restroom, and I see my friend John Doe being hit by Black Bart. You might say, okay, now can I defend my friend? Well, one of the useful things we say in the law here is you step into the shoes of the other. Whatever the other has done, if you're going to react to it, you're responsible for that. Since my friend John Doe started the fight by using unlawful force, okay, if I go in and I hit Black Bart, I don't have the defense of others, because the other here, my friend, started the fight. That's also why you should always know the total circumstances in the action. You know, on the other hand, if we're just sitting in a bar, I get up, I go to the bathroom, Black Bart comes over, hits my friend in the face. I come over, Black Bart is standing over my friend, punching him in the face. My friend is lying there unconscious, and I know my friend isn't violent, and I know my friend had no intention of being violent. If I go to defend him, that would be a lawful defense. Now, you sometimes hear the term Good Samaritan law. Most states have enacted Good Samaritan laws that encourage but don't require you to get involved. You are almost never under a duty in common law, and it's not in North Carolina, okay, that says you have to play Superman, you have to play vigilante. Now, if we look at an example here of Maryland statute, which is, I guess, Article 27, Section 12A, says, any person witnessing a violent assault upon the person of another may aid that person being assaulted by assisting in their defense. Again, remember, they're going to step into their shoes. So if that person escalated the assault, you got to be careful. Under these circumstances, a person may use force to protect another only if the threat of violence is occurring or immediate. And really the purpose of Good Samaritan law kind of bridges between the criminal and the civil, because what Good Samaritan laws very often say is, and North Carolina has one, and it doesn't really apply here, but we have something like it that for some different things, emergency first aid, for example. So what it's going to do is it says, well, we want you to act, but we know if you act poorly or if there's a mistake or a problem here, you might be civilly liable. We're not going to prosecute you criminally, but you could lose a lot of money. So North Carolina is essentially, and I'm glossing over a lot of this, says if you render aid to someone, let's suppose they're having a health issue, and you perform CPR compressions, and you don't do it very well, right? Or maybe it was reasonable to do that, but when you did it, you cracked a rib. The Good Samaritan law is going to say, well, you can't be sued for doing that. And you can see how that's bridging the criminal to the civil. The state's not going to prosecute you for performing CPR. And North Carolina is going to give you some protection. Now, in Maryland, it's going to actually go to these acts of assault. But let's move on, because many people are much more focused on the use of deadly force. Okay, and this is really going to be our introduction to Florida Man, the Good Samaritan law, stand your own ground type thing. It's really an extension of that in some ways. All right, so what's deadly force? Now, some people say, well, it's when you're trying to kill somebody, and that's not correct. Deadly force is any force that's capable in the circumstances of causing death or serious bodily injury. So you have to first of all think about the circumstance. Obviously, if you've got a gun, we usually will say that is per se or automatic deadly force. If you shoot a gun at someone, it's deadly force. Period. End story. You can't say, well, I was shooting to wound. I was shooting to knock the gun out of his hand. It's deadly force once you pull the trigger. A lot of the time we'll look at the circumstances. Is a piece of wood deadly force? Well, if I'm building a cottage, no. But if I'm swinging it around in a bar and it's a table leg, the answer is yes. So we have to look at how it was used, whatever we're using, was an object used, what did you do? And sometimes it can even be an individual who is unarmed and it's deadly force given the circumstances. Someone is unconscious. So let's take Mongo, who is 6'8" and 400 pounds and a triple black belt in Taekwondo. And he is going to attack Bambi, who is 4'1" and suffers from degenerative muscle disease and can't leave her wheelchair. And if Mongo attacks her, even with his hands, this could be a deadly force situation. Now, on the other hand, if she comes up to Mongo and she says, I'm going to hit you, well, what has he got to worry about? He's 6'8", 400 pounds. She's 4'1", 100 pounds soaking wet. She can't get out of her wheelchair. She can barely swing at him. He's not in any sort of significant danger. The rules providing a justification for the use of deadly force are similar to those for non-deadly force. And there are special rules for law enforcement officers. They have a little bit more leeway in using it. Now, many states, including North Carolina, traditionally, not so much anymore, had something in there that many people don't understand. And I think, again, this goes back to popular culture, kind of the cultural imperative in America that you don't back down from a fight. But most states, until fairly recently, had a requirement that you had a duty to retreat before you used deadly force. So in other words, if you had a situation where you could walk away safely, right, or you could pull a gun and pull the trigger, you had to walk away. The law basically said you can't play a gunfighter. You can't play Matt Dillon, if we're going to do an old Gunsmoke reference. You are supposed to act civilized. You're not supposed to kill another unless it's absolutely necessary, and if you can avoid killing them by avoiding the fight, you have to. Now, for different reasons culturally, this begins to change. And where does it change? It changes first in Florida. And this is the Florida Stand Your Own Ground law. Some of this goes back to a series of racial instances that happened in Florida, but there's also I would say a bubbling undercurrent of states and people who wanted to take action under the perception that things were going to hell in a handbasket, and it was time really to get the citizenry engaged again. But basically what Florida says is a person who is not engaged in unlawful activity and who is attacked has the right to stand his or her ground. Basically, this abolishes the retreat. Remember, for most states historically, until recently, you had a duty, if you could, to back down from the fight if the only recourse was deadly force. You didn't have the same requirement. If someone hits you, can you hit him back? Sure you can. Someone slaps you, can you slap him back? Yes. Someone pushes you, can you push him back? Yes. You can do all those things. You always could do all those things. But one of the things that we had said under the law was it gets more serious. It gets real when someone threatens you and the only recourse you have is to potentially kill them. Since we wanted to avoid homicides, we said you have to be the bigger person and back down. What Florida did, And as I said, this is kind of a cultural thing, is it said, no, you don't. Now, this became very popular because politicians could say, all right, we're going to let people stand their ground. I mean, it's a catchphrase. It's good marketing. Um, it is going to result in more death. But that didn't stop the general legislatures. So we have North Carolina General Statute 1451.2, which says basically what I just covered with Florida. You do not have to back down. If you're doing something lawfully, if you're in a lawful location, you're in the Waffle House and someone comes in, starts acting abusive, you have a concealed carry permit, and you can just walk out of the Waffle House. But instead, you draw your gun and you shoot him when he brandishes a knife or when he threatens people. North Carolina 1451.3, or excuse me, 1451.2 is going to say it's okay. You operated in self-defense. You stood your own ground. Now, we do say you can't do this with cops because we don't want to have open seizures on police officers. And that's North Carolina General Statute 1451.3. All right, well, let's do Make My Day. And again, this is a reference to a Dirty Harry movie, a Clint Eastwood movie from years ago. But some states have adopted Make My Day laws which remove limits on the use of deadly force for an intruder entering an occupied dwelling. An example here that's used in your text is in the State versus Anderson, the court interpreted the Oklahoma statute, which they use Title 21, Section 1289.25, as intended to remove any requirement that the force used must be reasonable in the circumstances. So here, it's not a matter of retreat, and we're going to talk about the Castle Doctrine in a second, but basically you can use disproportionate force if someone's coming on your property. And I would say, again, this is very much an American idea, a settler idea in some cases as well, that you can use deadly force to defend property. An occupant who reasonably believes the intruder has wrongfully entered the residence and intends to use some force, however slight, may use any force, including deadly force, to terminate it. So everything I talked about when I said proportional and reasonable, and there are exceptions in the law, and there always has been, including in North Carolina. So in North Carolina, we call this the Castle Doctrine. And I've got a separate slide on that in 1 second, but what's the Castle Doctrine? Because it exists in more than just North Carolina. One of the things is stand your own ground has always been in place in your house. You never had to leave your own house if you were threatened. It's long been the law that people who've been assaulted in their homes by a trespasser, so it can't just be your wife, your husband, your child, a lawful resident of the house, but someone who came in, can stand their own ground and use force as necessary to defend themselves and others. The privilege not to retreat is known as the Castle Doctrine. Even states that require you, and it's a minority of states now, it's 22, that require you to retreat before using deadly force say it doesn't apply inside dwellings, which are going to be houses or apartments. So what's North Carolina's? Okay. If you are the lawful occupant of a home, motor vehicle, or work, you are not required to retreat prior to using deadly force. So essentially, very early on, we had a form of stand your own ground. And under North Carolina General Statute 1451.2, you are presumed to have reasonable fear of death or bodily harm if someone's breaking in. So we have a rebuttable presumption. Now, I don't want to go too far into presumptions. That's more court procedure and evidence. But basically, there's two broad categories of presumptions. Presumptions that are irrebuttable, they never change, and presumptions which are rebuttable that can be overcome. But essentially, if someone's breaking in and you don't know who it is, there's a presumption they're going to do you harm. But if someone's coming in through the window and it's your spouse who forgot their key, you can't say, well, I have a presumption that they're dangerous. No, you don't. You are presumed to have a reasonable fear, presumed, so it's presumption, to have a reasonable fear, a rebuttable presumption, of death or bodily harm if someone is breaking in unlawfully or already broken in, but not if they're there lawfully. So let's take a situation that would be uncomfortable. Let's suppose you have a teenage child, and you know that you come into that child's room, and in bed you catch in an act of sex, you catch your underage child having sex with another. And the only way that other person got in your house was through an open window. You see the window. So they had invited that person in. Doesn't matter whether this is your child's a boy or a girl. And you're really upset. You do not want your teenage child to have sex, even if it's consensual. So you say, well, I've got the castle doctrine. This person broke in. I can shoot them. You cannot. Right? First of all, they were probably invited in by your teenage child. But second of all, you don't have any fear of death or bodily harm. And so you wouldn't be able to use the castle doctrine there. All right, let's move on and start talking about some acts of domestic violence and battered women. Every year, approximately 500 to 750 women kill men who have abused them. Now, here's the thing. For the use of deadly force, remember, it has to be an immediate fear. So, not always, but in most cases, a woman cannot openly face her abuser. They suffer a problem basically of disproportionate force. If you have a woman who is 5'1" and her abuser is 6'6", right? If she openly challenges him when the aggression occurs, okay, then she's going to lose. So one of the things that she can do is she can use deadly force. She can use a gun. She can use a knife. And she can use it in circumstances when it's not an immediate threat. So I don't want to get preachy here, but we could talk about, like, okay, well, we're willing to accept the no retreat doctrine, and we're willing to accept no immediate threat doctrine for a presumption in protecting a home, but when a woman protects herself, we're not willing to accept that. And battered women can be found in prisons in every state in the United States. So there has been an attempt to create a defense, kind of like the castle doctrine, kind of like stand your own ground, and this would be the battered women syndrome or the battered woman defense. So typically what happens is they are charged with a minimum of assault and battery, and sometimes they're going to be charged with a homicide. And remember, homicide in North Carolina, if we look at the big four, since we're not involving the automobile, you've got voluntary manslaughter, involuntary manslaughter, which is the lowest level, kind of negligent homicide. Then you've got second-degree murder, and then you've got the worst, first-degree murder. So depending upon the circumstances of a woman using this defense, she could be charged with anything all the way from a voluntary manslaughter to a first-degree murder. So in order to use the defense of deadly force, when she says, okay, I was in fear, right? She has to have a reasonable fear of imminent death or great bodily harm, even if in the past she's already been abused or hurt. So let's take this situation. We have an abusive spouse who beats his girlfriend or wife, and he bloodies her up, and he maybe, blackens her eye and beats her, and then he drinks a bottle of whiskey and falls asleep. So he's lying there, and she wakes up from being unconscious because he beat her. She might be bleeding, but she is not now in imminent fear of death. She can retreat, right? She can walk out the door. Now, what the law says is that because she's not in immediate fear right now, she can't use deadly force on the sleeping abusive spouse. Force used, deadly or non-deadly, is not justified if it's based upon past unlawful acts. What we are saying is, you go call the police. The police can arrest the abusive spouse. You don't do it yourself. The battered woman defense, often called imperfect self-defense, can be used sometimes to reduce the charge. So what will happen, because it doesn't meet all the criteria of our self-defense, is you go in and you plead. You say essentially, okay, yes, we don't quite meet all the criteria of perfect self-defense, which would require you to drop the charges, but there's enough there that it really prevents you from pursuing first-degree murder, or maybe even second-degree murder. Maybe it pushes it down to a manslaughter, voluntary manslaughter. So it could go from something of life without parole or death all the way down to a 3 or a 5-year sentence. So this kind of hit the media, became popular. One of the more famous instances of this is about 25 years ago. Barbara Sheehan shot and killed her husband. Now, she shot him 11 times. And at her murder trial, she said, I was in fear and I had been abused. And I was so afraid that when he woke up or the next time that he was going to kill me. Now, one of the interesting things that happens here, and it's kind of outside the scope of this, is let's suppose you're sitting on the jury and you believe Barbara here. And you say, okay, she had immediate fear. I know what the law says, but boy, if that was my daughter that was in an abusive relationship, or if that was my sister, or my mother who was being beaten up, and the only way she thought she could escape was to kill him, right? I don't know if I'd vote to convict. So this is a process called jury lawlessness, where the law may say clearly one thing, that this level of self-defense is not sufficient, but when it goes to the jury goes back there and says, yeah, well, we know what the law is, but the law here is wrong. So in much the same way where people argued that we should have stand your own ground, formally, you can argue that informally juries, jury lawlessness is called, will sometimes say, well, we're just going to ignore the law. And she was actually acquitted of the murder charge. Now, she was convicted of illegal use of a gun, which is a much less serious offense. All right, well, let's move away from killing people who are trying to kill other people or beat their spouses and talk about using force with property. Now, what can you do if someone is coming after your property? So there's a couple different types of property here. We're talking most of the time personal property. If someone's coming to steal your phone, take your purse, take your wallet, you have the right to use non-deadly force to protect property. If you know you are in no danger of being killed yourself, right? Your level of force, again, has to be proportional, and that means it's going to be non-deadly. You're not faced with a deadly threat, so you use non-deadly force. A person whose property is threatened may use non-deadly force to protect that property. And all states recognize this, and I think it's strongest when you're defending real estate, real property. It's still strong when you talk about using it to defend personal property, but it's so much easier to prove that you were on your land and this stranger came in than you were in public and there was a dispute about whose purse this was, or whose bag this was, or whose phone this was. That can be a lot harder to prove. Occasionally this can escalate to deadly force. If it's for real property, then the Castle Doctrine is going to get triggered. All right. Remember police officers, we had introduced that before. The use of force in making an arrest. In most arrests, you don't have to use force. It's unnecessary because most people will comply. If you think about the thousands of tickets that are written every year, people don't beat up police officers for writing speeding tickets. Now I know it can occur, but it's pretty rare instances. Mostly what will happen, probably the most common type of force is people will run. People will try to escape. At that point, let's suppose a police officer pulls over someone who is driving a car. And let's just suppose that they had gone through a stop sign and this guy says, I can't have another ticket. He jumps out of the car and he bolts. Well, we're not going to let the police at this point draw a gun and shoot and kill the guy who's running away because he rolled through a stop sign. Mostly what we're looking for use of force is we're looking for, how serious is the arrest? Police officers can detain the offender. They can use that level of force necessary to hold them in place and conduct a lawful search. They also can overcome any resistance. The person is screaming or moving or shouting. Well, handcuff time. They can prevent an escape and they can retake people. They also can protect themselves. They can protect others. They can even protect the prisoner if necessary, the person they're bringing into custody. Because sometimes people don't know what they're doing. Sometimes they're danger to themselves. Now, of course, this really becomes an issue. It's an issue when it's non-deadly force, and certainly police officers are sued or there are complaints made for non-deadly force, but it becomes much, much more serious when the police officer uses deadly force. And we're going to get to the Supreme Court case that really controls this in a minute. And it really took a Supreme Court case because in the past, we didn't question the right of the police to use deadly force as much. Generally speaking, police officers may use reasonable and necessary force in dealing with the public, whatever they need to do to make an arrest and control crowds. But deadly force cannot be used unless they have a reasonable belief that the person they're going to use the force on, presents a risk of death or bodily harm to the police officer or to others. So again, that example I used, can you shoot the guy who rolled through the stop sign? You can't. What about if you pull him over, you see he's got a gun, there is a hostage in the back seat, he jumps out of the car, he's running away, could you shoot then? You probably could. Do you have probable cause to believe that he committed a crime that caused serious bodily injury? Well, kidnapping sure qualifies. So, where did this rule really develop? Well, it really developed in a constitutional case called Tennessee versus Garner. And I'm going to simplify this case, but basically it works something like this. A police officer sees a suspect, in this case a young man named Mr. Garner, and he is committing a larceny, a robbery of a store, we'll say, burglary, doesn't really matter. And the police officer testifies, well, I knew that he wasn't armed, but he was running away and he was going to get away. So I knew he hadn't hurt anybody. I knew it was a nonviolent offense, but I drew my gun and I shot him in the back. And the Supreme Court looked at this, and there had prior to this been a rule that you could shoot fleeing felons. Since the larceny was a felony, that was okay. The police officer could shoot. Today, he can't. Because Tennessee versus Garner says, basically, deadly force can only be used when the person you are having to use it against, we'll say kill in shorthand, the police can only kill when the person they kill is a threat, a physical threat, who is going to significantly harm others. And, this case came down in the 60s. There was a lot of hemming and hawing about this case, but it's been the established rule for going on 50 years. All right, let's talk about one of the most serious crimes that occurs, and it occurs a lot. And that's drunk driving. And now drunk driving goes under different names. Sometimes you'll hear DUI, driving while impaired, or that's DWI, excuse me, or DUI, driving under the influence. They can mean the same thing. Different states will use different terminology. Excuse me. All states make driving under the influence a crime. And when we say influence, this can be alcohol, it can be beer, whiskey, wine. It could be any substance, including a lawful prescription that you take that render you incapable of safely operating an automobile. So one of the things is if you pull someone over, we want to have some scientific evidence to back up that you are incapable of operating the car. Now, 90 times out of 100, what are we talking about here? We're talking about a breathalyzer test. We're going to pull you over for ingesting alcohol, and we want you to blow into a breathalyzer and show that you are incapable of safely operating it, that your reflex time is down, that your spatial awareness is impaired. But of course, sometimes someone gets pulled over, and the cop says, well, I think you've been drinking. They do a simple test, or not. Maybe the person even refuses a simple test like, follow this pen. And when they make you follow the pen, they'll hold up a pen, they'll hold it up at eye level, and they'll say, watch the pen, and they'll move it from the left to the right and left to right. And the reason they do that is the first muscles that become impaired are the muscles that control your eyes. And for a lot of people when they're drinking, not all, it's not a 100% perfect test, is when their eyes are following that pen back and forth on the horizontal, because they're drunk, they'll bounce up and down. Because your eye will have to correct and recorrect, and it's an indication that, okay, this guy is drunk. And if it's not, it's also an indication he's sober. But one of the things we would like, and it's in most statutes, is we want to know their blood alcohol level. And again, we're focusing on alcohol here. So we want either a breath test, a blood test, or a urine test. Well, all of those are, to some extent, voluntary actions. You want me to breathe into this? No. You want me to urinate into this? I won't. You want to draw a blood sample? I won't let you. So police and prosecutors sometimes will want to take a sample. This is particularly true if someone says, I'm not going to blow. Right, 'cause at this point, there's only a couple ways you can get it. You can't physically force them to use a breathalyzer. It's impossible. It's also very difficult to draw urine. You can do it, but the easy thing is most of the time to do a blood test. So what you really want to do is you want to strap this person down so they can't move. You want to put a needle into their body. You want to draw out blood. Then you want to take that blood and see how much alcohol is in it. With some exceptions and conditions, we will allow obtaining this evidence. Now, most of the time, it's all done voluntarily. So most of the time, the question is, you are using force. This is what this chapter is all about, but it's consensual. So using force, we'll get to North Carolina in a minute. We've got a case came down in actually 2020. Reasonable force can be used to compel a suspect to give a blood or urine sample. But you've got to have probable cause that violated the law. If a guy is just, it's 2 o'clock in the afternoon, he gets out of work, the cops have been watching him for all day, haven't seen him drink a thing, gets in his car, they put the blue lights on, they say, you've been drinking. Guy says, I haven't. We want you to do a blood test. I won't. All right, we're going to force you. The courts would toss that. You must use reasonable means to obtain the sample. And this is subject to review of the courts. So one of the things is it a danger to someone? Let me give you a quick example. It would be interesting. I don't know if there's ever been the case, but I've thought about this sometimes. Let's suppose you pull someone over, you suspect that they are drunk driving. You say, well, I want to take a blood sample since you won't cooperate with the breath sample. And the guy says, I'm a hemophiliac. If you try to cut or draw blood from me, I'm going to keep bleeding and it's a danger to my life. Boy, if I was the cop at this point, and if I thought this was possibly true, right? I'm not sure if it goes to the hospital, because the cop's not going to administer it on the side of the road there. The hospital is really going to hesitate to take that. And I think a court would hesitate to order it. But let's look at some of the mechanics or other devices in making arrests. Handcuffs can be used and reasonable force can be allowed. What about chokeholds? And we're talking now just beyond even drunk driving. These are other arrests. Um, Chokeholds have come under a lot of criticism because they've led to deadly force situations, so they are limited. What about tasers? They can be used to incapacitate, but only if reasonable necessary to continue. I said I'd look at North Carolina, that North Carolina case. Let's go to the North Carolina case here. State versus Hoke. In 2020, a defendant refused to take a breath test, and a warrant was issued. Now, this is great for the cop, because if there's a warrant, that means you went in front of a judge, and assuming you told the truth, and there's no question about, yes, you presented factual information, and the judge looked at it and said there's probable cause. Cop has nothing to worry about. He cannot be sued. He has immunity at that point. But in this case, Mr. Hoke wouldn't cooperate and had to be held down. And the question was this a reasonable act, and could the state do this? And the court found yes, they could. The act was held reasonable because it was drawn by medical professionals at the hospital. And I think the key thing here in this case is they got the warrant. All right, let's talk about children. And we'll look at North Carolina rules in a minute, but let's look at children. Parents, can they use force? Well, parents and anybody who has custody of a child, lawful custody, may use reasonable force for disciplinary reasons. Now, there are some things you might say, well, this is a matter of discipline. My kid is writing with his left hand, and all good kids write with their right hands, and until he does, I'm going to beat him. I think the courts would say, no, you can't do that. But if the kid is reaching for an open flame and you hit the hand away, that's okay. If the kid had beaten up another child without cause and you spanked him, that's okay, right? All states have laws requiring that school officials, health professionals, and law enforcement officers report suspected child abuse. So, one of the things that kind of scares me about, and there's lots of good about it, don't get me wrong, homeschooling children is a lot of abuse of children is detected when they go to school. So if, little Cindy Who shows up at school and she has the classic defensive wounds, not the wounds and tears and scrapes that every child gets because they're kids, but they have classic defensive wounds, bruising on the arms, where they're trying to protect themselves. That's going to have to be reported and we can investigate it. But what about corporal punishment in school? I believe there's just one county in North Carolina left that allows it for public schools. Most public schools have discontinued it. Some states, most states I would say, forbid it in public schools. Now, private schools, you can give permission. You send your kid to a private school and the private school has beatings, seems to be okay. In states that permit corporal punishment, which is the infliction of physical pain, schools may use reasonable force to discipline them, but there are lots of restrictions. All right, let's look at North Carolina. As a rule, parents are not criminally liable if they inflict physical pain on a child if they are lawfully administering corporal punishments. They cannot endanger, that should be life, not lift, life, limb, safety, or disfigure the child or cause permanent injury. They also may not administer punishment to gratify their own evil passions. So let's suppose you were a sadist and you get enjoyment about the infliction of pain, and you beat your child because you are physically gratified by that. You enjoy, you're a sadist. If the reason you beat the child was not because the child did something wrong, but just because it's a Wednesday, I want to beat my kid, that's unlawful in North Carolina. All right, a couple other things here in North Carolina, then we'll wrap this up. What is child abuse? Any sort of long-lasting or permanent injury, any punishment that is ill will or cruel, anything that uses cruel methods or methodologies. As far as actually doing it in school, North Carolina allows schools to use corporal punishment. We have North Carolina General Statute 115C 390.4, but as I said, I believe there's only one county that still does this for public schools out of 100. But it is limited. First of all, your parents have to consent to it. It cannot be excessive corporal punishment. It can only be done by the principal, the assistant principal, or the teacher. And there's all sorts of supervisory. And it's pretty rare in North Carolina, possibly more common in other states. Okay, well, we came in about 50 minutes, a little bit longer than I thought it might have been. But that's basically the unit on the use of force, and whenever you're ready, you can move on to the next chapter. Have a good morning, afternoon, evening, and I will see you next time.